application can meet on the application, National Council for Civil Liberties, Equality and Human Rights Commission.
Yes, Mr. Fisher. Mr. Fisher, are you all right there? Because speaking for myself, and I'm sure my lords, I have no issue with you coming into the row in front.
My dear, grateful.
Thank you. Just make sure you've got all your papers with
Yes,
you.
my lady, can I ask my instructing solicitors to move up as
Of
well?
course.
My lady, my lords, I appear on behalf of the Appellant, the National Council for Civil Liberties, known as Liberty. Mr. Gowdy KC and Mr. Cosman appear on behalf of the Commission for Equality and Human Rights, which I'll refer to as the Commission. My lady, some housekeeping. The bundles you should have include the core bundle,
Yep.
supplementary bundle, further supplementary bundle, the authorities bundle, and then there are a few additional documents that I hope have made their way to you. The respondent's draft directions order in the event permission for judicial review is granted, and a letter setting out the difference between the appellant's and respondent's draft directions. A letter from Liberty updating the position as regards its crowdfunding, and the respondent's schedule of costs.
Yes.
Excellent.
Right. So let's just see where we are. A consent order was agreed as to the form of today's proceedings, and that's dated the 18th of June. I've got a copy of it in front of me. And this is to be a hearing to determine, 1, permission to appeal the refusal of permission to claim judicial review, 2, with the appeal against the refusal of permission to claim judicial review to follow. So the first application is permission to appeal.
Yes.
And that's the order we're going to do it. So what I would invite both you and Mr. Gowdy to do is deal only with permission to appeal the refusal of permission.
I'm grateful, lady.
Right? Thank you. And can I just say this? We have read the judgment of Mr. Justice Smith, we have read the skeleton arguments, and we have read the documents that we were asked to read. I'm sure we have all at different times gone into the supplementary bundle, and certainly we have read the additional supplementary bundle that came in. So you can take those as read.
Great. Well, my lady, I'll take my submissions in 3 parts.
Right.
On the application for permission to appeal. We'll firstly outline the factual and legal context for the application for judicial review that was before the judge below. Secondly, I'll address you on ground 1, why we say the judge was wrong to conclude the Commission had complied with its public sector equality duty when deciding on a 6-week consultation period. And then address you on ground 2, why the judge was wrong to find that 6 weeks was a fair and adequate period for the consultation. So starting with the factual and legal context for the application for judicial review. Through its claim for judicial review, Liberty challenges the decision of the Commission to run a consultation on proposed changes to its statutory code of practice on services, public functions and associations for a period limited to 6 weeks. Changes to that code are required in light of the judgment of the Supreme Court in For Women Scotland. My lady, I don't intend to spend a lot of time on For Women Scotland, but I do invite your ladyship and your lordships to turn to the authorities bundle, tab 19, page 530. And the only part of the judgment I wish your lordship to read is paragraph 264, which summarises the ratio of the judgment. Prior to that judgment, the statutory code that is an issue in these proceedings, the existing code, proceeded on the basis that trans people should be able to access single-sex services, facilities and spaces on the basis of their acquired rather than their biological gender. If you can turn to tab 9 of the supplementary bundle, that's the existing code of practice. There is a note on that front page at 294 following the UK Supreme Court ruling on 16 April 2025. The code is under review. And my lady, if you turn to page 383 of the bundle, this is an example of the guidance that is currently provided under the heading Gender Reassignment, Discrimination and Separate and Single Services. 1357, if a service provider provides single or separate sex services for women and men, or provides services differently to women and men, they should treat transsexual people according to the gender role in which they present. And at 1359, service providers should be aware that where a transsexual person is visually and for all practical purposes indistinguishable from a non-transsexual person of that gender, they should normally be treated according to their acquired gender unless there are strong reasons to the contrary. Now, notably, the guidance in the code as regards gender reassignment discrimination was not limited to those with a gender recognition certificate, which was the focus of the For Women Scotland judgment, but the consequences of the For Women Scotland judgment are likely to be wide-ranging. The Supreme Court has now clarified the law, but the For Women Scotland judgment does not descend into the detail of how that now clarified law is to be applied in practice. That is the question the Commission is seeking to address through amendments to the code. But it is a question that admits a range of reasonable answers and has given rise to significant controversy. My lady, can I invite you to turn to the authorities bundle again so that we can look at the statutory framework within which the Commission is operating. That's the Equality Act 2006, which is at tab 1 of the authorities bundle. We see at section 1 that establishes the Commission, then section 3 over the page, the general duty. The Commission shall exercise its functions under this part with a view to encouraging and supporting the development of a society in which, and then there are 5 separate matters, including there is respect for and protection of each individual's rights, there is respect for the dignity and worth of each individual has an equal opportunity to participate in society, and there is mutual respect between groups based on understanding and valuing of diversity and on shared respect for equality and human rights. Pausing there, I observe that there is an overlap between the obligations on the Commission when exercising its functions and its public sector equality duty under section 1491 of the 2010 Act. Section 8 overleaf provides another overarching duty that the Commission shall, by exercising the powers conferred by this part, promote understanding of the importance of equality and diversity, encourage good practice in relation to equality and diversity, promote equality and opportunity, promote awareness and understanding of rights under the Equality Act, work towards the elimination of unlawful discrimination, and work towards the elimination of unlawful harassment. The specific statutory function that's being exercised by the Commission in consulting on its revision to the code falls under sections 14 and 15. Section 14, the Commission may issue a code of practice in connection with any matter addressed by the Equality Act 2010. And subsection 2, a code of practice under subsection 1 shall contain provision designed to ensure or facilitate compliance with the Equality Act 2010 or an enactment made under that Act. Over the page, subsection 6, before issuing a code under this section, the Commission shall A, publish proposals, and B, consult such persons as it thinks appropriate. I note there is no time frame proposed there. It is a general consultative duty to which the common law applies in determining the fairness of the consultation. Subsection 7, Before issuing a code under this section, the Commission shall submit a draft to the Secretary of State, who shall, if he approves the draft, notify the Commission and lay a copy before Parliament. And subsection 8, where a draft is laid before Parliament, if neither House passes a resolution disapproving the draft within 40 days, the Commission may issue the code in the form of a draft, and it shall come into force in accordance with the provision made by the Secretary of State by order. So the Commission's conclusion of the consultative process, having conscientiously taken into account the results of the consultation, made any amendments to the code it may choose, is not the end of the process. The Secretary of State must then approve, it must be laid before Parliament, and 40 days must pass before it can be enter into force. Now, those in section 15 of the Act, overleaf, subsection 2 explains that the 40-day period shall begin with the date when the draft is laid before both houses, and shall be taken not to include a period during which Parliament is prorogued or dissolved, or both houses are adjourned for more than 4 days. I draw your lordships, your ladyship's attention to those provisions because there is at least some question as to the extent to which a 6-week extension to the consultation would make any difference to the overall timetable of the entry into force of the code. Subsection 1 of section 15 provides that section 14 applies to revisions of a code as well as the creation of a new code, and that's what we're dealing with here. And subsection 4 explains that a failure to comply with a provision of a code shall not of itself make a person liable to criminal or civil proceedings, but a code shall be admissible in evidence in criminal or civil proceedings and shall be taken into account by a court or tribunal in any case in which it appears to the court or tribunal to be relevant. In short, the statutory code of practice is not law, but it is legally consequential. And we say it heightens the importance of such a document being carefully considered and properly informed by a fair and adequate consultation. That's the statutory framework in which the consultation is being carried out. I turn back to the facts, and most of this will come from the supplementary bundle. On the 25th of April, which was 9 days after the For Women Scotland judgment was handed down, the Commission issued an interim update. That's at tab 10 of the supplementary bundle, page 401. And that interim update noted the For Women Scotland judgment, that the Commission was working to update the statutory and non-statutory guidance, and an acknowledgement that many people have questions about the judgment and what that means for them, and that the updated guidance will provide further clarity. At page 403, under the heading Our Work to Update Our Guidance, we see that the plan at that stage was to aim to provide the updated code of practice to the UK government by the end of June for ministerial approval. We then see at the top of page 404 that the intention at that stage was that the consultation would be launched in mid-May and would last for 2 weeks, and that in that period they'd be seeking views from affected stakeholders. Unsurprisingly, my lady, the respondent noted in its summary grounds filed in the High Court proceedings, you can see in the core bundle at tab 10, page 96. In response to the announcement of a 2-week consultation on revisions to a code of practice having very substantial consequences, a range of stakeholders wrote to the Commission suggesting that a longer consultation period was required. We see there that Amnesty International wrote and suggested 12 weeks. The Scottish Government wrote, which is now understood in fact to be Shirley Ann Somerville, MSP, the Cabinet Secretary of Social Justice in the Scottish Government, saying that the time was short. The chair of the Joint Committee on Human Rights queried whether 2 weeks was long enough, and the chair of the House of Commons Women and Equalities Committee suggested at least 6 weeks was required. Now, in its skeleton argument for these proceedings, the respondent confirms at paragraph 31 that in fact more letters were received. We see in the further supplementary bundle, tab 2, page 18, paragraph 31 of the skeleton, that in addition to those already mentioned, the Fawcett Society wrote to the Commission, and at the top of page 18 we see that the Commission's panel of counsel also wrote suggesting a longer period was required. We don't get any detail in the skeleton for this appeal as to what the content of those letters was.
Which paragraph were you referring to?
Paragraph 31.
Thank you.
Now, significantly, none of those letters were made available to the High Court. None have been made available to this court. That's significant because, as we'll see, the judge below relied in part on the existence of those letters to demonstrate compliance with the PSED. On the 14th of May, Liberty also wrote to the Commission after having consulted with trans organisations to express its view that a 12-week period was necessary for a fair consultation. That letter is at tab 11 of the supplementary bundle, pages 405 to 406.
Can I just say this, and it may only be me, but in my hard copy bundles there are no tabs, so it's the page reference that's really necessary.
Yeah.
Yes, yeah.
I'm sorry that's happened, but I will just provide page references from now. So 405 to 406 is Liberty's letter to Commission setting out that it considered that a 12-week period was necessary for a fair consultation. However, it appears that that letter was not received or considered by the Commission before it took the impugned decision in this case. As emerged in the High Court proceedings, the letter was sent at 14:50 on the 14th of May and acknowledged at 16:25 on the 14th of May, and the impugned decision was taken at a board meeting that ran between 1300 and 1640.
Where do we get those timings from?
We get the timings for the board meeting at 411 of the supplementary bundle. Sorry, 409 of the supplementary bundle.
So these are the draft minutes.
Draft minutes.
Yep.
And we see under the heading draft minutes, Wednesday 14 May, 1300 to 1640. The timing of the sending of Liberty's letter and the acknowledgement of receipt was given on instruction in the High Court and submitted orally to the judge.
Given on instruction.
On instruction.
So, and those timings were 14:10 and
1450, I thought you said.
1450, the letter was sent and acknowledged at 1625. So the best that can be said.
Sorry,
is,
sorry, can I just check? We don't have that in writing anywhere.
No.
Because, and you say it was said to the judge. I entirely understand and accept that, but the judge didn't record it.
what the judge recorded in his judgment (31) of the further supplementary bundle.
Yeah.
So at page 42 of the supplementary bundle, paragraph 32 of the judgment, about the third line down, one such representation was from the claimant, and in this case a letter dated 14 May. That letter referred to particular reasons why trans people would need longer than 6 weeks to respond to the consultation. There is some issue as to whether that letter arrived in time for consideration at the board meeting. However, that is not material.
No, well, we got that, but he doesn't give us the times that you've given us. And what is the status of those times?
My lord, those times come from the timing at which the email which attached the letter was sent, and then the email that was received. But all I can say is that as a matter of, it was evidence provided by submission orally in the High Court hearing. My lord, I'm instructed we can provide those emails if that's helpful, and I'll take my lead from your ladyship and your lordships. The board minutes is the next document I want to look at. They are at 409 of the supplementary bundle. We can see that in attendance at that meeting were the commissioners, a number of officers, and some guests. And my lords, as the judge below relied on these board minutes as contributing to evidence of compliance with the public sector equality duty, I'd invite you to read all of section 5 of the minutes, which is the totality of the minutes that addresses the decision to extend the consultation. My lady, the Commission did not file in the High Court, and has not filed before this court, any briefing or submission received by the board in support of agenda item 5. So the only information we have on what was taken into account in that meeting in deciding that 6 weeks was the appropriate length of consultation period is the content of those minutes and a press release that followed. In my submission, there is nothing in those minutes which evidences compliance with the public sector equality duty, and I'll come back to that when I come to ground 1. The press release that followed is in the core bundle at page 103. Paragraph that Mr. Justice Swift relied on was the second paragraph. In light of the level of public interest, as well as representations from stakeholders in Parliament and civil society, the consultation period has been extended. My lady, on the 20th of May, the Commission launched its consultation and published its proposed amendments to the Code. That document starts at page 420 of the supplementary bundle.
Sorry, I was just writing something. And that page reference?
420 of the supplementary bundle. And the consultation documents come in 4 parts. The first part, which is 420 to 424, is an introduction and a contextualization of the consultation. The consultation document proper starts at 425 and finishes at 482. And then from 483 to 503 are questions for individuals and legal professionals. And 504 to 530 are questions for organisations. If I start with the introduction document, that's at 420. The first thing the introduction document is, it contextualises this consultation as supplementary to an earlier consultation carried out in October 2024. We see that in the second paragraph. Last year, the Commission ran a 12-week consultation on wider revisions to the Code of Practice, made then to reflect a range of significant developments in legislation and case law since it was first published in 2011. And it says now, in light of the Supreme Court's consequential ruling and the widely expressed desire for authoritative guidance on its implications, the Equality Regulator has now opened a fresh consultation on a number of further updates. Now, that 2024, October to December 2024 consultation, it was at the date of this date as of 20th of May 2025, no longer available online. The next part I want to look at is under the heading Baroness Kishwa Faulkner, Chairwoman of the Equality and Human Rights Commission, said, and it's a long quote from the chair. And there are 2 points I wish to draw out from that quote. The first is the fourth paragraph, beginning, "It is important." The chair says, "It is important that our code is both an accurate interpretation of the law and clear to those who use it. So we want to hear the views on the clarity of these updates and urge all interested parties to respond to the consultation over the next 6 weeks." The next part is at the top of 422, where the chair acknowledges this is a complex area of law which bears on the rights of people with the protected characteristics of sex, sexual orientation, and gender reassignment. We know that there are strongly held views across our society, both about how the law should be interpreted and whether it reflects the right balance between those rights. So, if everyone's rights are to be protected, as the Supreme Court confirmed the law intends, service providers and their legal advisors need help to navigate these challenges. I don't intend to take you through the entirety of the consultation document, but I do highlight the following points. First, the consultation has high stakes. The revised code will be used as the statutory guide for service providers across the country on how they are to provide services to trans people and exclude them from such services. And the code must be taken into account by a court in any case in which it appears to the court to be relevant. Second, the document on any measure is lengthy and detailed. The entire document is 120 pages, and it includes 16 substantive amendments to the code, running to 58 pages of text, 52 questions for individuals and legal professionals, running to 21 pages of text. I note here that specific questions addressed to legal professionals rather reinforces the point that the legal issues involved in this code amendment are complex. And there are 90 questions for organisations, running to 27 pages of text. Third, the consultation is a supplementary consultation to the earlier October 2024 consultation exercise, but that consultation document is no longer available, so cross-referencing is not easy, though a number of organisations do have cached versions, and so organisations are able, through other organisations, to see that the proposed changes from the 2024. Fourth, the proposed amendments give rise to a range of very difficult issues. Now, before I address those issues, I emphasise that I highlight them not to say that the Commission has got them right or wrong, but to emphasise the 2 points made by the Commission Chair in the introduction to the consultation, namely that the issues do involve complex areas of law, and the Commission will benefit from the contributions of service providers and their legal advisors on those complex issues of law. And secondly, as the Commission Chair acknowledged, it's important the Commission gets it right, both in terms of one, accurately implementing the For Women Scotland judgment, and two, ensuring the code is clear and not open to misinterpretation. So as an example of those difficult issues, I invite your ladyship to turn to page 434 of the supplementary bundle. Where we see at 2.2.8 proposed guidance that if there is genuine concern about the accuracy of the response to a question about birth sex, then a birth certificate could be requested. And then subsequently, in the unlikely event that it is decided that further inquiries are needed, such as confirmation as to whether a person has a gender recognition certificate, then any additional requests should be made in a proportionate way which is discreet and sensitive. There are real questions as to whether a requirement or a request to see a birth certificate or a gender recognition certificate could be consistent with privacy rights. Two, another example, change 13.3, which is at 466. The proposed guidance in this section identifies that service providers may be at risk of acting lawfully no matter what they do in the new section on justification for separate and single-sex services. At 13.3.7, we see that the impact on those who will be excluded from the service includes both the impact on people of the opposite biological sex generally, and the particular impact on trans people of the opposite biological sex. In separate or single-sex services, a trans man will be excluded from the men-only service because his biological sex is female, and a trans woman will be excluded from the women-only service because her biological sex is male. Trans people are likely to be disadvantaged by this by comparison to people who are not trans. Then at 13.3.19, we see if a service provider or a person providing a service in the exercise of public functions admits trans people to a service intended for the opposite biological sex, then it can no longer rely on the exceptions. This means that if a service is provided only to women, and trans women are only to men and trans men, it is not a separate sex service or single sex service under the Equality Act. A service like this is very likely to amount to unlawful sex discrimination. And then at 13.3.20, similarly, if a service provider decides only to provide a service on a mixed sex basis without any separate or single sex option, that would be direct or indirect sex discrimination against women. This could be direct or indirect sex discrimination against women who use the service or lead to unlawful harassment against them. And a final example of the difficult issues arising are at 476. Section change 13.5, updated section on separate or single-sex services in relation to gender reassignment. The guidance in this section explains that trans people can potentially be banned from both male and female-only services. And then at 13.5.6, explains that a legitimate aim for excluding a trans person from a separate or single-sex service for their own biological sex might be to prevent alarm or distress for other service users. That appears to be a novel test, which is certainly open to real contestation in the context of a consultation.
So in essence, there are complex areas.
Complex areas.
Right.
And that's where I finished that part of the section. At this stage, my lady, it's useful also to identify the evidence that was before the judge that had been filed by Liberty. that evidence related to the particular situation of trans people and trans organisations, and why they said that 6 weeks was insufficient to enable intelligent consideration and intelligent response to the consultation. Witness statements were provided by Paul Roberts.
And you've identified these in your skeleton argument, the specific examples, and they're in our supplementary bundle.
Well, if your ladyship has had the opportunity to review the witness statements, I won't go through them.
We have. But if there's something you particularly want to draw to the attention of the court,
Well,
then
my
do
lady,
so.
perhaps I'll do that when I get to ground 2.
All right.
Because if you're already familiar with the witness statements, that's the better way to approach it.
Well, as I said at the outset, we have read into the case.
Excellent.
And the point that is of importance is that if there is something in those statements to which you particularly want to draw the court's attention, please do so.
Well, my lady, I will do so in the context of the grounds for permission to appeal.
Very well.
There's one final point on factual context, which arises from the respondent's skeleton argument at 37. And that's simply to note that the respondent has provided a degree of updating evidence. That's at page 21 of the further supplementary bundle. And has provided updating evidence on stakeholder engagement exercise that has been taking place, which is said to mitigate the alleged prejudice that is said to arise from the Commission's decision to not to extend the consultation period beyond 6 weeks. All I note at this point is that there is substantial updating evidence that could be provided on both sides and would be provided with permission for judicial review granted in this case in reply. And I invite you not to place any weight on that, because the respondent could also have noted further letters from more than 20 organisations that they've received, continuing to say that 6 weeks is far too short. I now move to part 2 of my submissions, which is why the judge was wrong in our submission to find that the Commission had complied with the public sector equality duty when deciding to limit the consultation period to 6 weeks. In this part of my submissions, I'll start with a brief summary of the law of the public sector equality duty, then set out the case that was made before the court below, look at the judgment below, and then make submissions on why the judge erred. First, the law. If we start in the Authorities Bundle tab 2, your ladyship and lordships are no doubt familiar with the public sector equality duty. It's section 149 of the Equality Act 2010. The duty is a detailed duty, and it has a number of sub-elements to it. A public authority must, in the exercise of its functions, have due regard to the need to A, eliminate discrimination, harassment, victimisation, and other conduct that is prohibited by or under the Act, advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it, foster good relations between persons who share a relevant protected characteristic and persons who do not share it. And then we see at subsection 3, having due regard to the need to advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it, involves having due regard in particular to the need to A, remove or minimise disadvantages suffered by persons who share a relevant protected characteristic that are connected to that characteristic, B, take steps to meet the needs of persons who share a relevant protected characteristic that are different from the needs of persons who do not share it, C, encourage persons who share a relevant protected characteristic to participate in public life. And then subsection 5, having due regard to the need to foster good relations between persons who share a relevant protected characteristic and persons who do not share it, involves having due regard in particular to the need to tackle prejudice, and promote understanding. So, my lady, the high-level submission is this is a detailed duty. It is not a broad duty which can be complied with simply by doing things which might, by chance, either further or not further the matters in subsection 1. There is extensive authority on the content of the public sector equality duty. It's sufficient for today's purposes, I think, to pull out, turn to 3 authorities only. First, Bracking in tab 10.
Page.
Starting at page 26, paragraph 26 at page 166. Does my lord not have tabs in the authorities bundle either?
And not in the electronic one, but for whatever reason.
Understood.
Doesn't matter. I'm sure they're there somewhere, but the page number is most helpful.
So, my lady, my lords, paragraph 26 is the oft quoted paragraph from Bracking, where the elements of the public sector equality duty are summarised and are then referred to in paragraph 17 as uncontroversial principles. I pull out from paragraph 26 a number of elements. Bullet 2, an important evidential element in the demonstration of the discharge of this duty is the recording of the steps taken by the decision maker in order to meet the statutory requirements. Then at bullet 5, which is referencing the Brown case, the public authority decision maker must be aware of the duty to have due regard to the relevant matters. The duty must be fulfilled before and at the time when a particular policy is being exercised. The duty must be exercised in substance with rigour and with an open mind. Bullet 6, general regard to issues of equality is not the same as having specific regard by way of conscious approach to the statutory criteria. Bullet 8, quoting from Hurley and Moore, Lord Justice Elias in Divisional Court. Provided the court is satisfied that there has been a rigorous consideration of the duty, so that a proper appreciation of the potential impact of the decision on equality objectives and the desirability of promoting them is made clear, it is for the decision maker to decide how much weight should be given to the various factors. And then at 78 of Hurley and Moore, the concept of due regard requires the court to ensure that there has been a proper and conscientious focus on the statutory criteria. And then one sentence later, in short, the decision maker must be clear precisely what the equality implications are when he puts them in the balance, and he must recognise the desirability of achieving them. Paragraphs 61 and 62 add to those observations.
That's page 171.
Starts at 170. Sorry, starting at paragraph 60. In the end, drawing together the principles and the rival arguments, it seems to me that the 2010 Act imposes a heavy burden upon public authorities in discharging the PSED and ensuring there is evidence available, if necessary, to demonstrate the discharge. It seems to have been the intention of Parliament that these considerations of equality of opportunity are now placed at the centre of formulation of policy by all public authorities. Then at 61, halfway down, or a third of the way down, there is a need for a conscious approach, and the duty must be exercised in substance, with rigour and with an open mind. In the absence of evidence of a structured attempt to focus upon the details of equality issues, a decision maker is likely to be in difficulties if his or her subsequent decision is challenged.
And this judgment, is this Lord Justice McComb still?
It is, yes. Yes, I think it is. Yes, it is still. Then Lord Justice Kitchen's judgment commences at paragraph 7. 70.
Thank you.
And then at 62, the judge notes that he had come to the conclusion in that case that too much of the respondent's case depends upon the inferences that counsel in the case invited them to draw from the facts as a whole rather than upon hard evidence. In the judge's view, there was simply not the evidence, merely in the circumstance of the minister's position as a minister for disabled people and the sketchy references to the impact on ILF fund users by way of possible cuts in the care packages in some cases, to demonstrate to the court that a focused regard was had to the potentially very grave impact on individuals in this group of disabled persons. Lord Justice Kitchen then makes a similar observation at paragraph 71. He says, I'm in full agreement with Lord Justices Nicola and Elias. For reasons they have given, it is simply not possible to infer that the minister ever considered the proposals with a proper focus on the particular matters to which she was required to have due regard. There is no evidence she directed her mind to the need to advance equality of opportunity, nor is there evidence she considered the proposals having due regard to the need to minimise the particular disadvantages from which ILF users and other disabled persons suffer, or the need to encourage such persons to live independently and to participate in public life and other activities. In his judgment, Lord Justice Elias made a similar point at paragraph 77. However, the second and related issue is whether the minister properly appreciated and addressed the full scope and import of the matters which she is obliged to consider pursuant to the PSED. There is simply no material from which one can properly infer that she did. A vague awareness that she owed legal duties to the disabled would not suffice, nor in my view was it enough simply to alert her to the obligation to have regard to the matters identified with the EIA and the IA. They did not identify her legal obligations. There is no evidence that she had her attention drawn to the positive obligation to advance equality of opportunity, nor indeed to the more specific obligations which the UK has undertaken with respect to the disabled. And then at 78, Lord Justice Elias rejects the submission by counsel in that case. In my view, Ms. Bush's argument on this point essentially came down to a submission that the court should assume that the Minister for Disabled People must be taken to be fully aware of her legal duties and to have complied with them. While it may be reasonable to assume that she would be well briefed on the purpose and operation of the fund, in my opinion, far from obvious that she would have had a clear understanding of her legal duties under the Equality Act. A similar point on the need for evidence appears in a more recent judgment of the Divisional Court in Good Law Project. That's at tab 15 of the Authorities Bundle, page 34. It starts at 313. The passage I wish to draw your attention to is at 343, paragraph 112. There, the judgment of the Divisional Court was what the public sector equality duty requires is not necessarily a particular outcome, for example, an open recruitment policy. Nevertheless, there must be some evidence of what precisely the decision maker did in the circumstances of these cases to discharge the obligation when deciding the method by which each relevant appointment was to be made. And at 113, we have considered with care the evidence filed on behalf of the defendants and cannot find any such evidence. The evidence in this case goes no further than generalities. My lady, my lords, there are other cases I could draw your attention to which make the same point on the importance of evidence, but that suffices for now. One other point I wish to draw from the authorities comes from the case of DXK, which is at tab 17 of the bundle, page 374. This was a case about the exercise of the Secretary of State's duty under Section 4.2 of the Immigration and Asylum Act to provide accommodation to a failed asylum seeker with care needs. At paragraph 133, judge summarised the principles established in the case law. And the principle I wish to draw your attention to is at 7. The duty is not simply to have regard to the relevant aims, the regard must be due. This regard requires a proper and conscientious focus on the statutory criteria, although it's not possible to be more precise or prescriptive, given that the weight and extent of the duty are highly fact-sensitive and dependent on individual judgment. What constitutes due regard is, however, context-specific. And then the court quotes from the Commission's own guidance: the greater the relevance and potential impact, the higher the regard required by the duty. Thus, where large numbers of vulnerable people, very many of whom fall within one or more of the protected groups, are affected, the due regard necessary is very high. The same will be true if the adverse impact of the policy is very high, albeit it affects a smaller group of people, the Commission's guidance. I turn now to the appellant's case in the court below. The appellant argued that in discharging its Section 14 Equality Act 2006 duty to consult on amendments to the Code, the Commission was exercising functions in relation to which the public sector equality duty applied. That proposition was not contested by the respondent and was accepted by the judge. Accordingly, the Commission was required to have due regard to the matters prescribed in sections 1491, 3 and 5 when, amongst other things, deciding on the duration of the consultation period. Given the potentially significant impact of the amendments to the Code on vulnerable people with the protected characteristics of gender reassignment, it was submitted that higher regard was due to those matters than might have been necessary in some other circumstances. The Commission has confirmed that no equality impact assessment was carried out prior to determining the 2-week consultation period or prior to extending the consultation period to 6 weeks. And the only evidence before the court below and today on the matters to which the board had regard when extending the consultation period to 6 weeks were the draft board minutes. And those minutes do not, in our submission, evidence compliance with the detailed duties under section 1491, 3 and 5. My lady, I do invite you to turn back to those board minutes, which are at supplementary bundle, page 411. That's where section 5 of the board minutes commences. And what we see from those minutes is that the board was considering a proposed resolution regarding the length and timing of the public consultation. We haven't seen that proposed resolution. We haven't seen any submission or paper that was put to the board. We only have these minutes. We then see at 5.2 a focus on the parliamentary timetable and a recognition that they had previously misunderstood how that parliamentary timetable worked, and that extending the consultation period to 6 weeks would not significantly impede the overall timetable to lay the code in practice in Parliament, nor would it affect the Commission fulfilling its duty to inform duty bearers and service users in a timely fashion. So the focus there is entirely on timetables. Then we see, given the extent of misunderstanding, misdirection and misinformation prior to For Women Scotland and the minimal impact extending the consultation period would have to the overall timetable, it's proportionate to extend. So one of the reasons for extending was misunderstanding, misdirection, and misinformation. That doesn't evidence in our submission consideration of the factors in section 1491, 1493, or 1495. There was then a recognition that a 2-week consultation period could be challenged, and one assumes that means legally challenged, which would delay laying the code in Parliament. So the focus there remains on timetables. At D, we're still focused on timetables. Consultation period will close on 30 June. Any delay commencing the consultation on 19 May is due to the time taken by the Executive to coordinate advice from external counsel, share the updated code of practice with admitted commissioners and the full board, and prepare communications for the consultation. And then at E, still concerned about timetables. Concerns were raised by the board regarding the time taken to respond to FWS. Commissioner Cash requested a copy of the project plan and the chairwoman agreed. We then, under the action heading at 5.3, see that the board agreed to extend the consultation to 6 weeks and set out a timetable for next steps. On the following page, decisions to issue a press release, to send letters to government, to convene a meeting of remitted commissioners to agree recommendations on the draft code, to send council's advice to remitted commissioners, to circulate the remitted commissioners' recommendations on the draft code. In my submission, there is nothing in those board minutes that evidences the requirement, that compliance with the requirements of the public sector equality duty. In particular, there is not a conscious approach to consider the matters in substance, with rigour, and with an open mind. In oral argument before Mr. Justice Swift, the Commission did not point to any other material as evidencing such compliance. Indeed, the Commission's case, as presented in oral submissions by Mr. Gowdy KC, was that it was not necessary for the Commission to evidence its compliance with the public sector equality duty, because such compliance could be assumed, given the Commission's statutory functions. I'll come back to this point, but that still seems to be the respondent's case before this court.
I know we've read the skeleton argument.
Turning to the judgment below, further supplementary bundle, tab 3, page 31. The judge addressed this ground at paragraphs 30 to 35. At paragraph 30, the judge accepted that conducting a public consultation, including determining the length of consultation, was a relevant function which required compliance with the PSED. At paragraph 36 of the judgment, the judge rejected the Commission's argument that its compliance could be assumed. However, at paragraphs 32 to 35, the judge indicated that he was nonetheless satisfied that the board minutes read together with the press release evidence that due regard was had by the Commission to the matters in section 149 of the Equality Act 2010 before deciding on the 6-week consultation period. My lords, I invite you to read paragraphs 32 to 35. I'm sure you already have, but again. Lady, the judge inferred compliance from the evidence that was available. It is not our case that compliance can never be inferred if there is evidence that, in substance, the public sector equality duty has been complied with. But in our submission, the judge's reasoning at paragraphs 33 to 35 shows inferences from no evidence that is capable of drawing those inferences from. In particular, in paragraph 33, without having seen any of the letters that were before the Commission, the judge infers the content of those letters. All these letters would have come from the same premise, that the course each proposed would promote the interests in section 149 because it would promote the formulation of a better and more robust version of the Code of Practice. My lady, in our submission, that was not an inference possible for the judge to draw from the evidence that was before him. Second, taking account of the need to ensure, this is at paragraph 34, taking account of the need to ensure that trans people had a fair opportunity to respond to the consultation was one of the important purposes of the exercise. There is no evidence of that. In defence of the judge's approach, the respondent relies on ZK against Redbridge, which draws on Lord Brown's approach in MacDonald and Royal Borough of Kensington and Chelsea. The ZK case is at Authorities Bundle, tab 14. Give my lord the page reference 282.
Thank you.
The proposition relied on by the respondent is at paragraph 84, where Lord Brown is quoted from MacDonald, whereas here, the person concerned is ex hypothesi disabled and the public authority is discharging its functions under statutes which expressly direct their attention to the needs of disabled persons, it may be entirely superfluous to make express reference to section 49A and absurd to infer from an omission to do so a failure on the authority's part to have regard to their general duty under that section. That I'm satisfied is the position here. The question is one of substance, not form. The appellant submits that MacDonald and ZK are very different cases to this one, and the approach adopted in those cases is wholly inapplicable to this case. We don't have MacDonald in the bundle, but it was a case challenging a care plan prepared by a local authority for a disabled person, where the statutory duty exercised by the local authority required it to assess the needs of the disabled person and prepare a plan to help secure equality of opportunity for that disabled person. It's no surprise in that specific context that Lord Brown thought it superfluous to refer expressly to section 49 of what was then the Disability Discrimination Act. In ZK, the statutory duty under which the local authority was operating, set out in paragraph 12, that was section 42 of the NAE, excuse me, section 42 of the Children and Families Act. And section 42(2) said the local authority must secure the specified special educational provision for the child or young person. Specified in relation to an EHC plan means specified in the plan. Again, the purpose of securing the special educational provision was precisely to help secure equality of opportunity for a person with special educational needs. Here, the statutory duty under which the Commission was operating was section 14(6) of the Equality Act 2006. I don't intend to take you to it, we've seen it. That is a pure consultation duty. It's a duty on the Commission, if preparing a new code or revising an existing code, to consult on that code. The exercise of that duty does not inherently require due regard to be given to any of the matters in section 1491, 1493, 1495 of the 2010 Act. The respondent's submission to the contrary relies on the fact that the document consulted on has purposes that overlap with the matters in section 1491, and the Commission itself always operates under the statutory duties in section 3 and 8 of the 2006 Act, both of which align to a large extent with section 1491 of the 2010 Act. But that extends the MacDonald authority too far, and is in effect the same submission that was made and rejected to Mr. Justice Swift, that one can assume the Commission's compliance with the public sector equality duty because it is always operating under a general duty under section 3 and under section 8 of the Act, which substantially overlaps with section 1491. In summary then, on ground 1, the appellant submits that the PSED applied to the Commission's decision to set the time frame for consultation. There is no evidence that the Commission had due regard to the matters in section 1491, 3 or 5 of the 2010 Act, and the judge's inference of compliance was wrong. The court is invited to grant permission on this ground, which has a real prospect of success. Moreover, there is another compelling reason to grant permission to appeal, namely that there is a real public interest in clarity on the extent to which the Commission, as this country's statutory body responsible for equality and human rights matters, is required to evidence its consideration of the public sector equality duty. The Commission's case in the High Court and here is that it benefits from MacDonald, so in the exercise of its functions, it need not demonstrate compliance. It is, in my submission, a compelling reason to grant permission to appeal, to have that point determined. Those are my submissions on ground 1. On ground 2, we argue that the judge was wrong to find that 6 weeks was a fair and adequate period for the consultation. The legal principles relevant to the lawfulness of a consultation exercise were not in dispute in the High Court. The appellant accepts the summary set out by the judge at paragraphs 10 to 12 of his judgment as accurate. The third gunning principle requires adequate time to be given for a consultation, and the relevant question is whether 6 weeks was, in the circumstances, so unfair as to be unlawful. While the appellant accepts that the fairness of a consultation can only be judged on the facts of each case, it is useful, in my submission, to go to the recent authority of Clifford as a recent example of a claim succeeding on ground 3 of gunning. That's in the authorities bundle, tab 18, page 418. This was a challenge to the consultation on proposals to make legislative amendments to the work capability assessment. 8 weeks were proposed for the consultation and allowed. My lady, I draw your attention to the summary of the law at paragraphs 24 to 25. It is sufficient to show that unfairness affects only a group of the persons affected to the consultation. Unfairness to the general body of consultees is not required. At 25, although it is unhelpful to refer to a varying standard of procedural fairness, the content of the common law duty and what the duty requires in any particular circumstances is highly fact-specific and can greatly vary from one context to another, An important factor in that context is that the decision in issue affect highly vulnerable persons. And at 27, the judge notes that the third gunning requirement, which is also relevant in the present case, namely the need for adequate time to consider and respond to the consultation, is necessarily fact-specific, fact-sensitive, and then quotes from Social Services Association, ex-party Association of Metropolitan Authorities, where Mr. Justice Webster said that sufficient time does not mean ample, but at least enough to enable the relevant purpose to be fulfilled. The evidence in that case is summarised at paragraphs 98 to 101. And I will go through this reasonably quickly. But in short, there was evidence from the chairman of the Work and Pensions Committee that 8 weeks was not sufficient for all affected people to engage and contribute. There was evidence from the Equality and Human Rights Commission itself, which we see at 99 subparagraph 1, where the Commission said, our concerns about this consultation exercise relate to the duration of the consultation and the absence of any analysis and published documents of the potential impact of the proposals on disabled people and other protected characteristic groups. Child Poverty Action Group also provided evidence asking for further consultations to be undertaken to ensure it was fair. A number of different disabled people's organisations complained about the 8 weeks, proposing a huge change would have a serious impact on thousands of people. We did not have enough time to properly engage with our members in accessible ways. Many of our organisations do not have the capacity to respond in such time. Equity, it is our view that to understand this consultation requires substantial knowledge of the law in this area. This will undoubtedly hinder many people's understandings of the proposals, including those who are directly affected. The issues are complex, and a brief public consultation on measures to see people lose vital income is entirely inadequate and dangerous. The timeline for this consultation is seemingly designed to enable an announcement at the autumn statement. And then at 6, under the heading duration of consultation period, Z2K, an anti-poverty organisation, said Z2K does not consider 8 weeks a sufficient period to consult on changes that could have substantial impact on disabled people and people's long-term health conditions. And finally, Disability Wales at 7, disappointed to see that this consultation did not give a full 12 weeks for a response. And 101, I apologise, my lady, William Scott, the Senior Policy Advisor at Inclusion Scotland, saying 8 weeks is wholly insufficient to give an organisation like Inclusion Scotland time to ensure that its members have the opportunity to engage with the consultation. Now, the judge's approach is then set out at paragraphs 130 to 132 at page 458. In short, the judge relied on that evidence to make the finding that less than 8 weeks for a consultation concerning such significant proposals was insufficient and so unfair as to be unlawful. We see that at 131.
Mr. Fisher, I accept obviously all that is being said, but it really comes down to this. Each case is fact sensitive.
I accept that.
And you've accepted that.
I accept that.
Yeah.
But I do say that the facts in that case and the evidence in that case are surprisingly similar to the evidence in this case about the ability of small organisations to represent their members and properly respond in a short period of time. And that's the evidence to which I'll come when I look at why I say that the judge went into error.
But it is also only fair to note that in that case the consultation documents were misleading.
Yes, yes.
And moreover, this is a case where the judgment had come out in the middle of April. It had been anticipated because the original hearing was in November of last year. And it is fair to say it was a much anticipated judgment. So a lot of people and organisations were on notice.
My lady, they were certainly on notice that the Commission was going to amend its guidance. How it was going to amend its guidance, they were not on notice for that. And in my submission, it is engaging with the detail of what the Commission has done, rather than the fact that there is going to be a consultation, that is causing problems for the trans organisations and individuals who have put evidence into these proceedings. The appellant's case in the court below was that a 6-week consultation period was plainly insufficient to enable trans people, trans organisations and others to give intelligent consideration and an intelligent response to the consultation. And the court was referred to the witness statements of Paul Roberts, Lauren Stoner and Simon Blake. Their evidence was not mere assertion that this is too short. We can't cope with it. We can't deal with 6 weeks. They gave very detailed evidence of why 6 weeks was insufficient. To summarise, the proposed amendments to the code have the potential to have very significant adverse impacts on the treatment of trans people, the services to which they're entitled, and their rights and dignity. And so in those circumstances, the demands of fairness in the consultation process were, we submitted, likely to be higher, relying on ex parte Baker. The evidence before the judge was that the trans community was particularly vulnerable and currently subject to intense scrutiny and frequent harassment. Trans people are vulnerable to poor mental health, self-harm and suicidal ideation. The evidence was that many currently perceive a hostile environment and that there was evidence of distrust of both consultation processes and the Commission in particular within the trans community, and evidence that some trans people were withdrawing from representative organisations that might otherwise assist them to engage in the consultation process. There was evidence that many trans people, including the thought leaders within the community, were personally distressed at the impacts of the For Women Scotland judgment and the Commission's interim guidance, and were consequently ill-placed to engage, support others to engage on the highly complex consultation. My lady, earlier I took you to the consultation document. It is lengthy, it is complex. It has 52 questions for individuals and legal professionals, 90 questions for organisations. And the proposed amendments are not always easy to follow because they've not been presented in a red line or strike through as compared to the current version. And the October 2024 consultation document is no longer available online. We don't make a complaint about that as in terms of that itself amounting to an unlawful consultation, but it does add to the complexity and the time required to respond. The proposed amendments involve, as your lordships have seen, complex issues of law and policy on which individuals and organisations are entitled to seek and should seek and receive legal advice before responding. As the majority of trans organisations do not have in-house legal teams, it's likely to take time to seek and receive that advice. For trans children and young people, there was evidence that the 6-week period running through the exam season, GCSE, A-levels and university exams, made it less likely that that extremely vulnerable group would be able to give intelligent consideration and an intelligent response. And finally, many trans organisations are also associations or service providers for the purposes of the 2010 Act. And so at the same time as supporting their members to respond to the consultation, they were having to look at their own constitutions and governance and consider whether they were acting lawfully in respect of their own trans-inclusive policies. That meant that their resources were dedicated elsewhere and they were constrained in the extent to which they were able to support members and organisations in their responses. The appellant accepted that what is fair in the circumstances depends on all the facts, and that included the public interest in promptly achieving clarity on how to implement the law in light of the judgment. However, The appellant submitted that the need for promptness cannot trump the need for a consultation process in which those most likely to be affected by the proposed changes are given a fair opportunity for intelligent consideration and intelligent response, and also noted that there was no evidence before the court below that a 6-week extension of the consultation period would in fact create any substantive delay to the date by which the amended code would come into force. That's because even on the Commission's proposed timeframe with a 6-week consultation, there was no intention to provide it to the Secretary of State until parliamentary recess, at which time the 40-day period would not run. Now, at paragraph 32 of the respondent's skeleton argument, there's an update on that. And the update says that there is an expectation, I won't paraphrase.
Paragraph 42.
32.
32.
Final sentence of 32.
Page 19, yeah?
Page 19, yes. It is presently anticipated that the code will become statutory guidance by or in November 2025. There isn't any indication even there what difference an extra 6-week consultation period would cause. I turn to the judgment below. Starting at paragraph 13, where the judge summarises the claimant's submissions, and then between paragraphs 16 and 29, dismisses the arguability of, rejects the arguability of this ground. In my submission, the judge erred in rejecting the arguability of this ground for the following reasons. First, the judge's reasoning on fairness is in the appellant's submission infected by his reasoning on the PSED. As the judge acknowledged in paragraph 15 of the judgment, a relevant matter in considering the fairness of a consultation period are the particular needs of those who may wish to respond to the consultation that may have something to say about the length of the response period. As addressed in ground 1, the judge wrongly considered that the Commission had done so when choosing the 6-week period when there is no evidence of such consideration. There was no consideration of the particular needs of those who are most likely to be dramatically affected by the revisions to the code, and no consideration of any period longer than 6 weeks. Second, the judge erred by mischaracterising the appellant's submission and the evidence before him when dismissing at paragraph 18 of the judgment the suggestion that the consultation response could only be formulated by taking into account the 2011 code and the proposed amendment set out in the October 2024 consultation. That's the second paragraph of the second sentence of paragraph 18 at page 38.
Second sentence of paragraph
18 of the judgment, page 38. I do not accept the suggestion that the consultation response could only be formulated taking account of matters referred to either in the existing version of the Code of Practice or information available only in the original October 2024 consultation document. That was not the appellant's case. The appellant accepts that it would be possible to respond to the consultation on the basis of the consultation documents alone. However, as with any consultation, a responsible consultee may wish to and arguably should seek to understand how the proposed amendments fit within the wider code. The evidence was that the witnesses, that the organisations who had given evidence in these proceedings wished to understand how the consultation document fit within the proposed amendments to the wider code, and that was causing them some delay in being able to provide a cogent response. Third, the judge's item-by-item dismissal of the issues addressed at paragraphs 21, 22, 23 and 24 of the judgment failed to engage with the cumulative effect of these matters. It is not that the need to take legal advice on its own requires longer than 6 weeks, or the controversial nature of the proposals on its own, or the competing day-to-day commitments of consultees, or the fact that trans people are vulnerable. The evidence that was before the judge showed that these factors cumulatively meant that 6 weeks was an inadequate period of time for the consultees to respond. In particular, the judge's observation that no potential respondent will be able to dedicate the entirety of the 6-week period to formulating a response illustrates the judge's failure to appreciate the nature of the problem, because it was not claimed that any individual organisation or any individual person would need more than 6 weeks to formulate a response on their own. Instead, the evidence presented was that an effective response from the trans community to the consultation demanded separate stages. I'll take you to the witness evidence shortly, but in summary, the evidence was that larger organisations first needed to seek legal advice, and all bar one of them had no internal legal resource. Then those larger trans organisations would then engage with and offer support to smaller trans organisations that didn't have the resource to prepare and support their members on their own. Then the larger and smaller trans organisations would be able to offer support to individuals who would otherwise be unable to respond cogently. Then those individuals would be able to formulate their own response. To make that submission good, can I take your ladyship to the witness statement of Paul Roberts, which is in the supplementary bundle.
It starts at page 14.
Starts at page 14. I'm looking at paragraph 10 and paragraphs 10 and 11. So, I'm sorry, paragraph 9. Paragraph 9, Mr. Roberts notes that the vast majority of the member organisations, very small in size, have very little funding, predominantly volunteer-led. Fewer than 10 of these organisations have any employed staff, and that such organisations and groups require to convene themselves around responding to a consultation on a complex area of the time that such organisations and groups require to convene themselves around responding to a consultation on a complex area of law, let alone convene responses around the clients and stakeholders, can be considerable. He says it would be a challenge to convene such responses within a 12-week period, let alone 6. And then he notes that the majority of our trans or non-binary led member organisations are focused on supporting trans individuals in relation to social and well-being opportunities, so their primary purpose is not responding on policy matters. Most, he says, are reliant on larger organisations to provide them with guidance on how they could do this work, including on responding to the consultation. And he says that some of the larger member organisations are planning to produce guidance to assist the smaller organisations and the individuals they support to respond to the consultation, but that it hadn't been possible to produce that guidance by then, and it wouldn't be out for another week. Now that's around the 6th of June. This will leave only 4 weeks remaining on the consultation once this guidance goes out, and it will be very hard for the smaller organisations to then digest the guide and use it to form their own individual responses to the consultation in time, and even more so for them to convene their clients and stakeholders to respond in time. A similar evidence is provided by Lauren Stoner, whose witness statement starts at page 25. And her evidence at at page 28, paragraph 10, is that mermaids would usually work with sector partners to produce guidance to help other organisations and individuals understand and respond to this type of consultation. And then she gives an example of what happened with the 12-week consultation run last year on gender questioning children. She says at further down paragraph 10 at the top of page 29, producing this kind of guidance for understanding and responding to the Commission's consultation is particularly challenging given the volume of questions and short time period, and it has not been possible to publish this yet.
And at 11, she makes the point which you've already made about the exam period.
Yes, exactly. Simon Blake makes a similar point about the staged process at paragraph 9 of his witness statement, which is at page 37 of this bundle. That before respondents are able to complete many of the questions, there's a stage of seeking expert legal advice. So, my lady, I come back to the judge's observation that no potential respondent will be able to dedicate the entirety of the 6-week period to formulating a response. That wasn't a response to the argument that was put before him. The argument that was put before him is that in the way in which trans organisations are set up to operate, in the way in which they have typically responded to consultations, larger organisations have supported smaller organisations by producing guidance. In order to produce that guidance, they need to seek legal advice because there are legally complex issues in this code. That takes time. They then need to produce the guidance to smaller organisations. The smaller organisations then need to digest that guidance before they can support individuals to respond. And the point was that that process, that staged process, could not reasonably be carried out within a 6-week period. Further, my lady, the judge's characterisation of the impact or effect of the vulnerability of trans people also didn't reflect the evidence. In his judgment at paragraph 24, the judge says this: the next matter is the submission that trans people are particularly vulnerable and for that reason are likely to need more time than 6 weeks to respond. In its judgment, the Supreme Court recognised the trans community as vulnerable. I also accept that some individuals may be deeply affected by the conclusions stated by the Supreme Court. It is only human nature that, on occasion, all of us might tend to shy away from or delay dealing with matters that we consider daunting or distressing. But even accounting for all this, I do not consider it arguable that a 6-week response period is unfair. My lady, the evidence was not that trans people were shying away from a matter they found daunting or distressing. Instead, the evidence was that the vulnerability of trans people at this particular moment in time was such that it did two things. It meant that trans organisations were already stretched in supporting these vulnerabilities and therefore not well resourced to respond urgently to a critical consultation. It also meant that trans organisations had significantly more work to do to encourage or cajole other trans organisations and individuals to respond to the consultation. That comes out of paragraphs 12 to 14 of Mr. Roberts's witness statement. We're back to the supplementary bundle, starting at page 14. Paragraph 12 is at page 18. So So there, Mr. Roberts says, we're hearing from some member organisations and groups that individuals who have been volunteering with them and who are accessing their services for some time have been withdrawing from those organisations and groups. This is because of those individuals' immense fear that they are now not able to use public toilets and other services. So they're afraid to go outdoors and into public. The Commission's interim guidance in particular has sent many in the trans community into a damaging spiral. This is placing an extra burden on our member organisations and groups to do outreach to those individuals, to check on their well-being and safety, which is slowing, and in some cases making impossible work at those organisations and groups on responding to the consultation. In 13, he notes that some of the most strategic thinkers in the trans sector are personally affected by the For Women Scotland judgment, deeply worried on a personal level about their ability to access services and facilities that they've long been able to access. And that because these individuals are now having to cope with the worrying personal impact alongside their work in responding and supporting others, this has upended an already vulnerable sector and naturally distracted these individuals from that work responding and supporting others. And then at 14, the consultation comes at a time when the sector is already under extreme pressure responding to other removals of trans rights which have been enjoyed for years, including the provision of trans healthcare. And then at 19, diminished trust in the Commission around trans rights means that more time than 6 weeks is required to do the hard work of reaching out to those organisations with low trust and convincing them of the urgent need to respond. So this wasn't about shying away from a matter that trans people found daunting or depressing. This was a structural problem for trans organisations and a resourcing problem for trans organisations by having to, at one and the same time, look after their own needs, support the vulnerabilities of their members and individuals, cajole their individuals and members to engage in the consultation, and also think about how they would respond as organisations, service providers and associations. My lady Lauren Stoner, at paragraph 14 of her evidence.
Page
30 of the supplementary report. She says, this consultation comes at a time when the trans population, and indeed organisations like Mermaids supporting them, are facing ongoing and intense scrutiny and attack politically in the media, on social media, among the general public. While the trans population is a uniquely small population, they are disproportionately targeted with harassment and abuse, politically, physically and online, which among other things has a long-lasting emotional toll on the individuals affected as well as those trying to work to support them, like Mermaid staff. And then about 2/3 of the way down the page, I think the third to last sentence, as a result, this is the critical part, as a result, Mermaids and other organisations are having to provide greater emotional and practical support to its service users than might be expected during a consultation period. So again, the vulnerability problem was not about shying away from engaging in an issue that trans people found difficult. It was about resourcing and practicalities. And the judge failed to grasp that in his judgment. Finally, the judge erred in mischaracterising the appellant's submission that on account of the parliamentary recess, this is a paragraph 28 of the judgment, the appellant's submission that on account of the parliamentary recess, a 12-week period would not substantially delay the issue of the revised code, as focused on, as the judge said, not on what is fair, but on what might not be inconvenient. In our submission, this was directly relevant to fairness. If the public interest in the prompt issue of guidance was a relevant factor in considering fairness, which the judge at paragraph 28 of his judgment accepted, and if the respondent was unable to put any evidence before the court to show that a 6-week extension would cause any delay, that was relevant to the weight to be attached to the public interest in the prompt issue of guidance in the fairness balance. And in my submission, by dismissing that submission as focused not on what is fair, but on what might not be inconvenient, the judge was wrong. My lady, my lords, for all those reasons, our submission is that the judge was wrong to conclude that it was not arguable that a 6-week consultation was legally inadequate to allow an intelligent consideration and intelligent response from those most likely to be affected by the revised code. There was ample and compelling evidence before him that that was indeed the case. The court is invited to grant permission on this ground, which has a real prospect of success. Those are my submissions.
Just allow me one moment, James. Thank you very much indeed. Mr. Gowdy.
My lady, my lords, we take, if we may, as our twin starting points, what Lady Justice Andrews has said in granting permission for the case to come to this court. Now that's in the supplementary bundle at tab 4, pages 44 and 45, and in particular paragraph 2 of Lady Justice Andrews' reasons. First of all, she says that on the face of it, Mr. Justice Swift's reasons for refusing permission are, quote, difficult to fault, unquote. We would say impossible to fault. And secondly, she says that the respondents made some, quote, powerful points, unquote, in their PD 52 para 19 statement. Powerful indeed. We endorse those points today in public. The ladies, the public sector equality duty in section 149 of the 2010 Equality Act is, as is very well established, a have regard to duty. No less than that and no more than that. And this case is about the discharge of that duty by the Commission for Equality itself in relation to the further development of its code of practice so as to do two things in the language of section 14 of the Equality Act. First, to ensure compliance with the Equality Act, and second, to promote equality of opportunity. So it is all about equality. A prior consultation on revision to all the chapters of the code and 9 protected characteristics had concluded on the 3rd of January this year, and this further development with which we are concerned by the Commission of part only of its equality code, 6 chapters and 3 protected characteristics, being gender, reassignment, sex and sexual orientation, arose out of the authoritative, albeit no doubt controversial, decision of the UK Supreme Court in the For Women Scotland Equality case at tab 19.
Mr. Gowdy, may I just interrupt, just on an information point? My reading of the papers is that the consultation is due to end on the 30th of June. Is the court to take it? The consultation has carried on and is still due to end on the 30th of June.
My lady, yes.
Thank you very much.
And my lady, as part of the discharge of its equality duty, the Equality Commission has been consulting. It has indeed received very many responses already, but also it has received representations from various sources that the consultation period, initially of 2 weeks, was too short. And the Commission, therefore, duly considered whether to extend the period. It was responsive. It extended the period to 6 weeks, 3 times as long. And as your ladyship will have gathered, Liberties' letter of the 14th of May was not seen by the EHRC board at its meeting that day. And we say that the inference is irresistible, that the Commission, as a public authority, subject to the public sector equality duty, did have regard to the equality duty and the protected characteristics when determining the extension, matters, of course, with which, by the nature of its role, it is very familiar. And in our submission, it would be wholly unrealistic to suppose otherwise. The duty is, again is very well established, is a substantive duty rather than a procedural duty. It's focused on the general advance of equality aims rather than being a procedural duty. The duty is to have regard to the need to achieve equality aims, not to achieve a particular result, or, quote, to do anything specific in addition to or independently of the functions which the authority is carrying out, end of quote. That's a quote from the Luton Community Housing case, paragraph 17. That's Authority 12 at page 219. So the crucial question is always whether the duty has been discharged in substance. It's not a matter of boxes ticked good, boxes not ticked bad. The duty is to have due regard. There's no duty as to substantive outcome. The weight given to the various factors, including but not confined to the equality implications of a decision, is a matter for the decision maker. Yet again, very familiar stuff. And the court will no doubt have noticed that when our learned friend was quoting from various judgments, he often ended the quotation at the point where the next observation from the court was that weight was a matter for the decision maker. So there's no formulaic duty to complete an equality impact assessment in every case. Doing that is one method of demonstrating compliance. It can be done in other ways. We addressed the public sector equality duty from paragraph 2 of our paragraph 19 statement, and in particular, as always, context is of vital importance. And that statement is at tab 1 in the further supplementary bundle. And in paragraph 2 itself, we quote from Lady Justice Simler, as she then was, in the ZK v Redbridge case, to which our learned friend has referred. He quoted the reference to the MacDonald case in the Supreme Court and Lord Brown, but then did not go on to say what Lady Simler said following on from that, and that, as one can see at Authority 14 at page 311, or in our statement, our paragraph 19 statement of paragraph 2, is to say that the logic of the approach identified by Lord Brown and MacDonald is that in any case where the public body concerned is discharging its functions under legislation expressly directed at the needs of a protected group, it may be unnecessary to refer expressly to the PSED, or to infer from an omission to do so a failure to have regard to that duty. In other words, the nature of the duty to have due regard is informed by the particular function being exercised and not vice versa. And then there's reference to the Redbridge case. No error in reliance on the very purpose of the arrangements sufficient there to meet the public sector equality duty. And as we observe at paragraph 4 on page 4 of our para 19 statement, prompt completion of the consultation is a relevant consideration for people with Equality Act protected characteristics. And a great deal is said on the other side about difficulties of making prompt responses to the consultation. But on the other hand, of course, those with protected characteristics are precisely the people who are prejudiced if there's a period of uncertainty for themselves and others. So we summarise our case in relation to the PSED ground at paragraphs 47 to 50, inclusive of our statements. Of our skeleton, I'm grateful. Having at paragraph 16 and 17 of our skeleton set out the principles applicable to the PSED by reference to the authorities, including Bracking, Baker, Bridges, Shake and ZKV Redbridge in this court, that is at respectively CAB 16, 6, 13, 12, 16, and also in HOTAC in the Supreme Court at tab 11. And our learned friend has taken your ladyship to Bracking, both Lord Justice McComb, Lord Justice Kitchen and Lord Justice Elias. Reference was made to what Lord Justice Elias said at paragraph 97, that there was no material there to found a particular inference. Our submission, of course, is that that is entirely distinguishable from our case in terms of whether on the specific facts of this case, a particular inference being drawn. So that essentially is what was ground 2, but has been shifted, been promoted, so to speak, to ground 1, with the consultation period ground slipping from ground 1 to ground 2. At paragraphs 19 to 21 of our skeleton, we set out principles in relation to consultation and the time allowed for responses to consultation.
Have you left ground 1 then?
For the time being, my lord.
All right. Can I just ask you then, if just on the factual bit, you said something about the letter from Liberty.
Yeah.
Is that common ground? Because there's a short period, but very short period, if the timings that were given to us were right on the email, where the board was still meeting, but the letter had arrived at the commission.
Yes.
So it wasn't presented to the board.
No, it was not. Those are my instructions.
Right. But the press release, was that a final press release or just a draft press release?
That? It was a final press release, I'm instructed, and all.
Right, thank you. And that refers to representations made. That those were before the board, were they?
Well, certainly there were representations, of course, from a variety of parties.
Yeah,
whether or not they included the particular one from Liberty.
Well, it
On the
did,
same
you just
day.
answered that, but the other ones were before the board, were they?
Oh yes, all of them. The only one that seems to have been a ship passing in the night was the one from Liberty.
Thank you, sorry to interrupt.
No, not at all, my Lord. Lord, as to the gunning principles that govern consultation, we have pruned the authorities' bundle a little, so we haven't included Gunning and Moseley and one or two other familiar cases. But at paragraphs 19 to 21 of our skeleton, we set out the gunning principles in relation to a fair consultation. The overriding requirement, of course, being that a consultation should be fair, including the third gunning principle, that is an adequate time for response. Principles, of course, now approved by the Supreme Court in Moseley. And we refer to the need for a successful challenge to demonstrate clear unfairness, something that has gone clearly and radically wrong. That's the Royal Brompton Hospital case at tab 9 in the authorities, page 129, paragraph 13. So there is a balance of proportionality between prompt decision making on the one hand, which in our submission is in itself obviously desirable to say the least, and countering uncertainty as soon as possible, and on the other hand the need for adequate time for responses on the other hand. But that, of course, is adequate or sufficient or reasonable. It is not extensive or desirable. The Commission says 6 weeks, which is what the Joint Committee for Human Rights argued for. Liberty does not say that it cannot itself respond within 6 weeks. Its case is that some others may have difficulties with the deadline. Liberty either suggests 12 weeks plucked out of midair, or it does not identify any period at all. It does not advance an argument why it is no less than 12 weeks that is necessary. There is nothing to say that 12 weeks is a requirement. Well within 6 weeks, well before the 30th of June next Monday, there have been many responses, very many responses. That is telling in our submission. So again, the learned judge was conspicuously and entirely right for the reasons he gave after a full hearing, and the contrary is unarguable. The test, of course, reaffirmed by this court in the Bloomsbury Institute case, not in the authorities bundle, but cited at paragraph 11 of Mr. Justice Swift's judgment, paragraph 69 from the Bloomsbury Institute case, is whether the process was so unfair as to be unlawful, a formulation, I think, commenced by Lord Justice Sullivan in one of the Greenpeace cases. We say it was not unfair at all, and certainly not so unfair as to be unlawful. And we further submit that unfairness must be considered in the round. Some may want more time to enable a more leisurely response, but others may want a prompt decision, with the period before decision being sufficient rather than generous. Yet others may, somewhat inconsistently, want both. But three things are abundantly clear. First, there is currently uncertainty following the For Women Scotland case. Secondly, the uncertainty should, if reasonably be possible, be ended or at least reduced. The court has been taken to Section 3 of the 2010 Act, the general duty imposed upon the Commission, in relation to which there are 5 elements which it includes mutual respect between groups based on understanding and so forth. And one of the unsatisfactory features of this interval between the Supreme Court decision and the revision process of the code being concluded is friction between different groups, which is aggravated by the lack of clear guidance. Third, the Commission completing its part of the process, following not only the consultation period, but obviously the subsequent conscientious consideration of all the responses, a mammoth exercise, and producing its draft code and submitting it to the Minister and the parliamentary process is an important aspect of moving forward to reduce and ultimately eliminate the uncertainty. So we submit that acting expeditiously, reasonably expeditiously, and good governance are not incompatible. Far from it. And all the more important in a context where there are other processes that delay the eventual, definitive and comprehensive outcome.
Mr. Gowdy, may I just get this clear in my mind? My understanding thus far is that the trigger for this further consultation process was simply, and I use that word carefully, the decision of the Supreme Court. You'd had the much wider consultation in 2024. Yes. This was contained and it was all focused on the ramifications of that judgment.
Yes.
So that people knew that.
Yes.
Can I just also, while you're being asked questions, ask you to deal with the submission that was made in relation to, well, now that we're in the summer, an extra 6 weeks makes no difference or might not make any difference?
Well, my Lord, in our submission, that's wholly unrealistic. It's highly likely to make a difference because the timetable involves sequential steps. And therefore, the sooner the Commission is in a position to finalise its draft after the consultation and get that draft over to the Minister as a draft, the sooner one is on one's way to avoid an eventual conclusion. Therefore, if any stage of the process is delayed, there's a propensity for that to have an adverse effect on the overall timetable. And we, of course, are concerned here with the Commission's role as consultor in relation to its code, not on the roles of others, and bringing that consultation to a conclusion sooner rather than later, after giving conscientious consideration to all the consultation responses, those already received and those yet to be received, including hopefully from Liberties. And we address the length of the consultation period from paragraph 5 of our section, paragraph 19 statement. Where have I put that? Yes, we address there why the judge was right to find that the 6-week consultation period was not so unfair as to be unlawful and that the contrary was unarguable. And we address the 4 specific points made on the appellant's behalf. And that in our submission says it all, save to add, as we do at paragraph 59 of our skeleton, that the 4th of the alleged errors, that's ASA 43 Roman 4, is immaterial. The practical reality is that the longer it takes for the Commission to issue guidance in the form of a revised code, following consultation and conscientious consideration of consultation responses, the greater propensity for the highly undesirable misinformation and disinformation in a highly prolonged debate that has already taken hold to take hold further to the detriment, not benefit, of persons with protected paragraphs or with protected characteristics. And at paragraph 32 of our skeleton, we note that a longer consultation period than 6 weeks would, quote, materially affect the already extended likely end date of the publication of the revised code, which it is hoped is on target for at any rate November of this year. It's material that the consultation under challenge is much narrower than the consultation on the entirety of the code and all 9 protected characteristics. The judge was right that the consultation with which we are concerned is, in his words, quote, more discreet, unquote, flowing from the update to the legal definition of sex, and indeed is freestanding. As the judge said, the present proposals arise from the single issue decided by the Supreme Court. And what is happening is that the Commission is doing 2 things in parallel at present. First, it is updating the code, which is vintage January 2011. It's completed consultation on that, on the entire code, with all the protected characteristics, and over more than a decade's development. But the statutory processes following that consultation will not be completed, and the revised code will not come into effect until the second item has caught up. That, of course, is the second consultation, specifically with respect to the implication on the content of the code from the Supreme Court. And we set out at paragraph 12 of our skeleton the elaborate and extended timetable pursuant to section 14 of the Act, governing publication of the new Act code effectively in 6 stages. And we observe at paragraph 13 of our skeleton, and it is an important point in our submission, that the effect of the requirements of the timetable is that unnecessary delays at an early stage in the process cannot readily, if at all, be mitigated further down the road. The longer it takes for the Commission to submit a draft version of the code to the Secretary of State after the second consultation is completed and the response is considered and the Commission's decision made, the longer it will be before the revised code can be finalised and actually published. The big question on parliamentary timetable is whether the draft order is laid before or after the parliamentary recess, which is looming. The House of Commons will sit for a short while in September and then break for the party conference season for 3 weeks in the habitual way until the 13th of October. So a further period of consultation would take one, depending on how long it was, obviously, but we're talking beyond the 30th of June. If one goes into August, that's obviously problematical, and there would then be the question of the steps needed to be taken at the parliamentary level. As we state at paragraph 14 of our skeleton, upon publication, the code becomes an important reference point for all those who need to understand and comply with requirements to which they are subject under the Act. And at paragraph 28 of our skeleton on page 17, we explain why the necessity for the Commission to update the code following the For Women Scotland case and the Supreme Court judgment there has been and remains pressing. And the fact is that there has been a pretty huge number of responses. The latest figure I have is 12,356. That is from organisations, legal professionals and individuals. They continue to come in. Our learned friend made some reference to Lawrence Stoner, the CEO of Mermaids, and what Mermaids said, perhaps particularly at paragraph 16 of Lawrence Stoner's statement, about the difficulties of responding in accordance with the timetable. But in fact, that seems to have been a little overstated, because Mermaids responded only yesterday. So they managed to get it in before next Monday. So many have not found any problem in submitting responses in time, indeed well in time. And no doubt there will be others between now and the 30th of June in the way of these deadlines. Things can hot up as one gets near to the deadline. But the timetable obviously is affected by the time it will take to digest all the responses and conscientiously consider them after the consultation period, and engagement and participation during that period in a variety of ways are duly concluded. So we set out our case on the consultation ground, paragraphs 51 to 59 inclusive of our skeleton. There's no material, if any, dispute between the parties as to the relevant legal principles to be applied, and we submit that the application of those principles leads to only one conclusion. The judge was right. There's no arguable basis for legal challenge. There is no legal principle that a consultation period must be more than 6 weeks, or for that matter, more than 2 weeks. There's no compelling reason for it to be 12 weeks or more than 6 weeks in the circumstances of this case. The equality duty and the interest not only of trans people, but also, for example, of women deprived of appropriate single-sex spaces, points strongly towards an early resolution. This is reinforced in a situation where misunderstanding and misinformation are rife. The situation is one in which uncertainty and delay would be contrary to the interests of those with protected characteristics, all the more given the other processes that have to be gone through. Sometimes the general interest does not lie where it is claimed to be, and this is such a case, because the Commission can, should, and has, in our submission, taken a broad and common sense view, having regard to all aspects of its role and responsibility, and the learned judge has given a common sense, with respect, common sense judgment, and therefore we urge that permission for judicial review should be refused, and permission to
We're only at the first stage, Mr. Gowdy, which is permission to appeal.
yes, that permission to appeal is unarguable. The judgment below is entirely correct, and that whether one looks at it in terms of permission to appeal or in terms of permission to apply for judicial review, somewhat overlapping concepts, the answer is the same either way, and is the answer that the judge gave, that there was no breach of the public sector equality duty by the Commission, and the revised period of 6 weeks was a lawful period for consultations. And there have been a number of responses from legal professionals, rather more from organisations, and the great majority have been from individuals. And that's where matters stand. The Commission acted perfectly properly when it decided that it would extend the period, but would not do so for longer than a 6-week period. That was striking a reasonable balance between considerations which point in both directions, and one needs to have regard to the pointers either way, and not to focus exclusively on reasons why it may have been desirable in an ideal world to have had a longer consultation period, a longer period of uncertainty. I mean, to some extent, uncertainty is likely to be diminished once the Commission has published its revised code. In other words, when the consultation responses have been considered, because although not definitive, it does give an indication of what the code is quite likely to say, and could be treated on an interim basis for those who have to have something to go on while the parliamentary process is gone through. So it is of value in its own right for the Commission to be able to complete its part in the process sooner rather than later. But it is also important that they should complete their part in the process sooner or later, so as to avoid any question of delay in that respect having a knock-on effect to what happens in the department and in the parliamentary process, particularly with the uncertainties as to dates. So, my lady, unless I can assist further, those are our submissions.
You've not addressed Mr. Fisher's compelling reason, which is that the irony of the Commission not itself having carried out any sort of written impact assessment.
Well, there are two answers to that. I mean, one is that an equality impact assessment is not a requirement. That is being formulaic and concentrating on procedure rather than substance. So my answer in 2 words is, so what? Also, I think anything else is just a different way of making the same submission. It's not about recording. It's not a bad idea, of course, to record it, but it's not an essential element by any manner of means. And as explained by Lord Brown in MacDonald and by Lady Simler in the Redbridge case, it's unnecessary to draw attention to the obvious, which is that what this is about is the Commission for Equality and Human Rights revising its code on equality and human rights. That is the very subject matter. And that is blindingly obvious to to everyone.
Thank you.
Thank you, Mr. Gowdy.
Thank you very much indeed.
Mr. Mitchell, do you follow?
It's not Mr. Mitchell.
I'm so sorry.
My lady, no doubt, apology on whoever completed that form, probably from our team. Mr. Mitchell was my junior at first instance.
Yes.
He unfortunately was part heard on something else for today, and I now have the benefit of Mr. Stephen Cosman.
Well, would he like to speak?
Yeah, but my lady, if he would like to speak, then I give way.
Thank you.
Thank you, my lady. I have nothing to add.
After all that.
Thank
Thank you very much indeed. Yes.
My lady, briefly in reply, can I start by responding to Mr. Gowdy KC's so what proposition? The courts have addressed the so what proposition in many cases and have been very clear that it is necessary to demonstrate compliance with the public sector equality duty through evidence. Now, there is an exceptional case, which is the McDonald case, as applied in ZK. But we are not in that territory. The duty in this case was a duty to consult. If the McDonald case applies to the Equality and Human Rights Commission when it is exercising a duty to consult, then it applies to all of the Equality and Human Rights Commission's exercise of duties. And it is never required to demonstrate compliance with the PSED. The so what argument is, in my submission, dangerous and inconsistent with principle. It gives rise, in our submission, to a ground that has a realistic prospect of success, but also, in response to my Lord Justice Dingemans, it is another compelling reason to grant permission in this case, because if the position of the Commission is that it does not need to demonstrate compliance with the PSED in the exercise of its functions because it is the Equalities and Human Rights Commission.
I thought the submission was that they didn't need to have an equal impact assessment in order to demonstrate it. Not that it had to, that it didn't have to demonstrate it.
If that was as far as the submission Mr. Gowdy KC made in response to my Lord's question. But earlier in his submissions, Mr. Gowdy KC referred to the submissions that were made in relation to bracking, and the fact that bracking addressed the absence of evidence, and he said, and that is this case is entirely distinguishable from that. It wasn't my learned friend's submission that it was distinguishable on the facts. He didn't point to any evidence that demonstrated compliance by the Commission. The basis for Mr. Gowdy KC's distinguishing of bracking was the exercise of the public functions of the Commission, i.e. because we are the Commission, we are in a different situation. And my Lord, in my submission, that is wrong in principle. It gives rise to a ground of claim that has a real prospect of success, and it is another compelling reason for this court to grant permission. My lady asked questions about, clarifying questions to clarify that this consultation was responding solely to the For Women Scotland judgment, and we're not at odds on that. Yes, that is entirely the basis on which this consultation is being run. And it is true that this consultation is narrower in one sense than the consultation that took place between October and December last year. It's narrower insofar as it's about a single issue. But as my lady, my lords have seen, that single issue has effect throughout the code, through 8 chapters of the code, giving rise to a consultation document of 120 pages. Moreover, it is a consultation that engages the public interest at a far greater level than the consultation last year and involves issues of far greater complexity than the consultation last year. In the respondent's skeleton argument at paragraph 23, the respondent confirms that the consultation in October to December last year generated in excess of 400 responses. Now, we've heard today in oral submissions that this consultation, albeit narrower, has already generated 12,356 public responses. Now, the number of responses, the fact that people have been able to put in responses because they care deeply about this consultation and the impacts it may have, particularly on trans people, tells us nothing about the quality of those responses. So the bare number of responses that have gone in is not, as was implied, indicative of the fact that, in fact, people have been able to respond within six weeks, and it's all fine. The fact that Mermaids has been able to put in a response tells us nothing of the quality of that response. So, my lady, I invite you not to place any weight on the fact that this is, as Mr. Gowdy and I accept, narrower in terms of the scope of the consultation, because it is not the scope of the consultation that we say gives rise to a need for longer than 6 weeks. It is the cumulative effect of the import, the consequences, the complexity, both legal and policy complexity, and none of those things applied to the previous consultation for which 12 weeks were available. Lady, this is of probably of little import, but my learned friend suggested I didn't take you to any of the authorities that said that the weight to be placed on the regard that is given by a decision maker is for the decision maker themselves. I think I took you to Bracking, paragraph 24, tab 10, page 166, number 8, and I think I read that passage out loud.
Mr. Fisher, I'm sure we're all satisfied that yours was a very careful, focused and detailed submission.
Thank you. My lady, I think those are my submissions, but let me just...
Yes, do.
Would you bear with me for just one moment? Lady, my lords, 2 final points. I'm correctly reminded in response to my Lord Justice Dingemans' question or observation about Clifford that there was also misleading documentation. That in fact, at paragraph 137 of the judgment, Mr. Justice Calver found that he still would have found the consultation was so unfair as to be unlawful on the time point alone. And the final point is in relation to my learned friend's submissions about the need for a swift promulgation of updated guidance in light of the misinformation and disinformation. I observe simply that it's a confusing submission insofar as misinformation and disinformation was identified in the board minutes as a factor weighing in favour of extending the consultation period. If we could, I can take you there.
No, I can remember it in particular. Got it.
Those are my submissions.
We are very conscious that time really is of importance. We're going to rise now, please don't go away, to see if between ourselves we can work out an idea of when a decision can be given. All right?
Court rises. Just to let everyone know the live stream is still running.
They're making Trump expletive. The live stream.
No, exactly. I think he knew the live stream was on.
Oh no, I'm alright for a little bit, but my colleague might. Thank you. Shouldn't be my main takeaway point from that experience.
I'll just be back in a moment.
Court rises.
We are extremely grateful to the council and those who are working with them, and clearly a great deal of work has been done for the very helpful and focused submissions, both written and oral. As I said at the outset of this case, there had been considerable reading in, and there's been a lot of listening this morning. We're going to retire now, and we will return at 3:30 or as soon thereafter as we can do, when a decision and reasons will be given.
Court rises.